Good evening, ladies and gentlemen. Welcome to Bangunan Sulaiman for this evening talk titled In the Seat, 60 Minutes with Gordon Nardell, QC, Investment Treaty Arbitration in Asia, What's Happening? The talk will be around an hour with 30 minutes of Q&A at the end for you to address the panel. We have two experienced personalities with us this evening. The talk will be delivered by Gordon Nardell, QC, and will be moderated by Raghunath Kesavan. A little bit about your moderator this evening. He's a partner in Masters Kesavan and is a former president of the Malaysian Bar. And he's also a commissioner of the Malaysia Competition Commission. Please join me in inviting Mr. Raghunath.
Thank you, ladies and gentlemen. We have with us today Gordon Nardell, QC. He's a barrister practicing at 39 Essex Chambers, specializing in energy law and international arbitration. And our topic for today is investment treaty arbitration in Asia, what's happening. Essentially, it is not really new investment treaties, but it has picked up over the years. And in the Asian context, it is gaining popularity. At one time it was, and then it tapered down. The idea is that with international, with foreign investors, which would require a little bit of protection, there's a need for some compensation if something goes wrong and things like that. So what you have is that investment treaties, either it will be a bilateral investment treaty or free trade agreements, or you have the ASEAN agreement, investment agreement as well. So we have Gordon Nardell with us today to give us a little bit of introduction maybe for some. For the rest would be what is the latest development, how does investment treaty arbitration work within the context of the Kuala Lumpur Regional Center for Arbitration. Gordon?
Well, very many thanks for that introduction, and profuse thanks to KLRCA for this invitation. And thank you all for coming along. It's a pleasure to see some familiar faces, and I'm sure it'll be a pleasure to get to know others after the session. As I'll explain later when I deal with one of my proposed topics, one of the historical problems in this region has been a lack of awareness and professional training in investment treaty work, and so it's particularly pertinent and particularly welcome that KLRCA has placed itself in the forefront of professional training by organising not just this session but a whole series of sessions on investment treaty arbitration with an Asian focus. And the bar has been set very high by two of the sessions that have taken place in the last 6 months with really top practitioners, Lucy Reed from Freshfields and Loretta Malintoppi from Eversheds have spoken very recently on these topics, and I'm afraid I'm going to mercilessly plunder some of their slides rather than reinventing the wheel, as members of the bench and arbitrators are wont to say to me, my submissions gain nothing in repetition, and I think the same is true of statistics and points that can be made in this area. So I'm going to assume a degree of knowledge. What I'm not going to assume, however, and it gets rather dangerous if one does, is an understanding of the proliferation of acronyms that inhabit this area. There are so many acronyms, many of which are so similar that sometimes I forget what they mean myself. So I will try to remember to explain acronyms, but if I don't, then please do stop me. And indeed, if there's anything that you're unsure about or that you feel you haven't got, just do stop me and ask a question. I want to make this quite an interactive session, and there will, of course, be time for more formal questions and answers and contributions and expressions of incredulity later on. As has been said, I'm a barrister practicing mainly in London and also with a presence in Singapore and Kuala Lumpur. I'm a member of 39 Essex Chambers, which of course does have a presence in Kuala Lumpur. Just to add to everybody's confusion, I'm about to move to 20 Essex Street Chambers. I'll be very sorry to leave 39, which is an absolutely superb set with some excellent colleagues. But I think it's a very, in a sense, it's a very good development that the English bar has become so much more mobile than it was even before I joined it from the solicitor's side of the profession in the mid-90s. I think it's a sign that the English bar has, from its rather creaky history, become every inch a modern profession. So I'm sorry to move in some ways, looking forward to the move in others. So let me say a word or two about the scope of this evening's session, what I'm going to cover. As I say, the scene to some extent has been set by the previous contributions made by Lucy and Loretta. But let me explain what I'm going to deal with and how I'm going to deal with it. I'm going to start with a bit of context, just a quick recap of some of the main trends and facts that were dealt with by Lucy and Loretta. And I'm going to say a word or two about what I think is a theme running through these topics of a lack of perceived legitimacy to investment treaty arbitration insofar as it affects Asian states. And that reflects itself in many ways. In some ways it reflects itself in who's peopling investment treaty arbitration, who's sitting, who's appointed, and it can reflect itself in some ways in the structures, the procedures, the processes, the way these things are handled, and occasionally in the substantive law that's laid down by tribunals. And I'll pick up this question of legitimacy in its various guises as I go along. My substantive topics are going to be this. First of all, the gunboat arbitration problem, raising directly the question of legitimacy. I'll explain a little later why I call it the gunboat arbitration problem. But that's really going to be about who is deciding our investment treaty arbitration disputes involving an Asian party, either as respondent state or as investor, why there's a problem and specifically what we can do about it. Then I'm going to move into this concept of soft law. Soft law is a hot and recurrent topic in international arbitration. Rarely do I open my inbox in the morning and find it's not clogged with books and papers and seminars on the topic of soft law in international arbitration. What we mean by soft law is the idea that arbitral tribunals are having regard to instruments which are not themselves legally binding, statements of policy, guidance, guidelines, advice of one sort or another. And I want to look at how soft law is affecting the practice of investment treaty arbitration. Next topic, one or two aspects of ethics and procedure pulled out of a whole range of potential ethics and procedure topics. I'm going to focus on two. First of all, the question of third-party funding, debate on which has really been reignited by the recent publication in October by the Hong Kong Law Reform Commission of a consultation paper on third-party funding for arbitration in Hong Kong. And I think that that's a very informative paper for a general discussion about that topic in Asia as a whole. And then the question of transparency. Arbitration is generally a confidential procedure. Confidentiality doesn't lend itself terribly well to the kind of public interest, public policy content of investment treaty arbitration. So I want to look at what's going on there, what are the trends, what are the prospects. And finally, the question that's on everybody's lips, will the TPPA make a difference? The wonderful thing about the Majestic Hotel is that you get the star delivered to your room every morning, and I've flicked through it, and every day I found something about the TPPA and this high-level political and public discussion that's taking place now that it's been signed and is under final negotiation. So those are the themes that I'd like to cover. Let me check the technology is working. Nearly. Excellent. So let me set the scene. First of all, just a word or two. This is mainly recap with one or two added points. So apologies for those who attended Lucy and Loretta's sessions, but just to bring everyone onto the same page, those who weren't able to attend those. As we know, investor-state dispute settlement, I'm afraid that's the first recurrent acronym. Investor-state dispute settlement is quite different from international commercial arbitration. International commercial arbitration is a purely consensual procedure between parties who very often are in a position of equality. ISDS, investor-state dispute settlement, is very different. It's far more political, and it belongs in the sphere of international law, and it has its origins in diplomatic protection. Historically, before investment treaties took off, which is really in the 1960s and then exponentially in the 1970s, if an investor domiciled in one state had a difficulty with the way the government of another state was treating its inward investments, it would ask the consular or diplomatic authorities of its home state to intervene on its behalf. And you can see how investor-state dispute settlement, investment treaties, are really the lineal descendant of that process. But instead of intervening on a political level in each case, what the host state, the investor's home state, does is negotiate a formal international agreement with the host state for the investment, under which there are going to be self-help arrangements for investors. So investors have the right to certain legally binding protections, and if there's a failure in providing those protections, they can submit a dispute, they can submit a claim to binding international arbitration. Inevitably, it's highly politicized, and it's for that reason that it raises questions of legitimacy. Bilateral investment treaties, and indeed multilateral investment treaties, come in all sorts of different shapes and sizes and flavors, but they tend to have recurrent themes in them. They tend to contain a chapter which sets out a series of substantive protections, and they are strikingly similar. National treatment, in other words, a state agrees to subject foreign investors to treatment no less favorable than it would its own investors. FET, fair and equitable treatment, another of those wretched acronyms. The idea that investments are treated to a certain minimum standard of substantive and procedural fairness. Expropriation provisions frequently feature in ISDS disputes. Most bilateral investment treaties contain a provision not only that the host state must not take over an investment, must not expropriate an investment, but must not implement measures having equivalent effect. And the question of whether measures have an equivalent effect, and if they do, whether they're justifiable, is an enormous topic that fills the records of awards of international tribunals. The most significant forum in terms of number of cases brought by investors is ICSID, the International Center for Settlement of Investment Disputes. It's an offshoot of the World Bank based in Washington, D.C. It's by no means the only show in town, but it is certainly number one in the stakes. Considerably more than half of investor-state dispute settlement claims are brought through ICSID. And so I'm going to tend to focus on ICSID, the ICSID Convention and Rules and ICSID decisions, in order to illustrate some of my points. What about the trends then in ISDS in Asia, particularly South and East Asia? Well, again, this is pretty much a recap, and I'm going to go into some of these in a little more detail in the next couple of slides. A lot of agreements. Asian states have been very busy in concluding bilateral investment treaties among themselves and with states in other regions. They've been nearly equally busy in concluding multilateral arrangements, of which the latest, of course, is the TPP, the Trans-Pacific Partnership Agreement, but they are party to disproportionately few disputes. And I'll look at some of the detail of the statistics. But the trend in general terms is an upward one, and it's excellent that KLRCA has anticipated growth in investment treaty arbitration in the region, partly through organising a series of talks like this, and partly through its bilateral cooperation agreements with ICSID itself and with the Permanent Court of Arbitration. And I'm sure that that confidence in growth is well placed. As I say, we'll look at some of the statistics in a moment. Slow growth in awareness and the practice of investment treaty arbitration in Asia has, however, meant that other regions of the globe have got a bit of a head start on us. And that is manifested when you look at who is determining disputes. The arbitral community, if I can call it that, is utterly dominated by individuals from the Western and Northern hemispheres. And I think that's one of the reasons why there's now such a perceived legitimacy problem in so many quarters in investment treaty arbitration in this region. Another important trend is the political uncertainty in the whole process. Until quite recently, probably the last 4 or 5 years, there was almost near unanimity among states negotiating bilateral and multilateral investment treaties. Ever since BITs started to take off, certainly from the 70s onwards, they were seen almost unanimously as a good thing. States were very enthusiastic to display their multilateral, their free trade credentials by entering into bilateral investment treaties with as many states as they possibly could, demonstrating that their doors were open, their arms were flung open in welcome to foreign direct investment. There has been something of a change in the wind for a whole host of reasons, partly to do with a number of very significant awards made by international tribunals against states in in America, huge awards against Bolivia, Ecuador, Venezuela, which has prompted those 3 states to carry out what some commentators have called a hard exit from their investment treaties. That's spilled over to some extent into more established legal systems. For example, the well-publicised announcement by the Australian Gillard government 2 or 3 years ago that it was no longer proposing to adopt a blanket policy of including ISDS clauses in its bilateral investment treaties, but would consider things on a case-by-case basis. And that was only partly political. It wasn't entirely a response to the Philip Morris Asia claim. It was in fact prompted by a report by an extremely well thought of independent and non-political body called the Productivity Commission, which carried out a cost-benefit analysis and ended up scratching its head as to whether entering into these treaties with ISDS provisions was really in Australia's best interest. But whatever the reasons for these hard exits or subtle change in positions, it sparked off a certain trend, and there's been a political change in the wind. Some states are adopting a softer approach than others. Indonesia, in this particular region, is adopting perhaps a slightly harder line than some other states. But in general terms, there's much greater caution, not only towards whether ISDS provisions are inserted in treaties in the first place, but to the content and terms of ISDS and the structure of the mechanisms, and we'll see some signs of that. So that's all I wanted to do by way of setting the scene, just to set the overall context. Let me then turn to my first substantive topic, what I'm going to call the problem of gunboat arbitration. But let me in turn set that up with a few statistics and updates. Again, many apologies to Loretta, Malintoppi and Lucy Reed for shamelessly plundering some of their statistics. What I've done is taken their figures, which were in turn largely derived from the ICSID 2015 first semester statistics, and I've supplemented those with some statistics from other sources, not least an excellent piece of research by Morgan Maguire of the Investor State Disputes Review, a very well-researched and reasoned publication which was unveiled at a conference organised by the National University of Singapore in December 2013. There is a problem of up-to-date statistics in this area, not least because there's a time warp in getting statistics. Statistics can be quite generic when they're published at the outset of an investment treaty arbitration. And of course, you can only tally factors such as nationality of arbitrator or choice of institution with outcomes once you know the outcome. So there's an inevitable time warp. Not all the statistics I'm going to give you are therefore measuring exactly the same thing at exactly the same time. But I think the broad thrust of what they illustrate is valid to make the point that I'm proposing to make. So let's just look at some of the statistics. First of all, the rising trend in the sheer numbers of disputes involving a party in the I've included in this Asia and Oceania, so not just Southeast Asia proper, but also Australasia and the Pacific Island states. So this is the Maguire December 2013 dispute, and quite a strikingly exponential rise in the number of disputes. So for the 15 years from 1987 to 2002, a total of 23 disputes in which either the claimant or the respondent state was based in Asia or Oceania. But for the 10 years 2003 to 2013, 173. So a staggering increase in the sheer volume of disputes. Nevertheless, it's still conspicuously low relative to the number of investment treaties concluded by states in this region. So if you look at the global figures, as at the end of 2014, 3,268 bilateral investment treaties concluded, and rather fewer, but nevertheless a significant number of multilateral agreements. Of those, 517, in other words 16%, quite a sizable chunk, have been concluded by East Asia and Pacific nations. But only half of that in terms of the number of disputes. So only 8% of cumulative disputes down to the end of 2014 involved an Asia-Pacific party. And if you look at South and East Asia proper, the proportion gets even smaller. And that is because of the Asia statistics as a whole, a huge chunk, just over half, are accounted for by India and Pakistan, so 14 and 8. And the statistics for other states are really very modest indeed. So Indonesia leads the pack with 5. Malaysia has 2, and that's two bit arbitrations to which Malaysia has been a respondent. There's also one arbitration in which a Malaysian domiciled investor brought a claim against a third state. And just to keep everyone cheerful, Brunei and Singapore have clocked up 0. So in other words, South and East Asia proper, ignoring India and Pakistan, it's only 4% of global disputes. So a huge disparity between the treaty-making activity in the region and the treaty dispute participation activity in the region. And that has had certain consequences, and they include these. And it's this question of who populates the arbitral village. Now, if only an arbitral tribunal dealing with Asia-Pacific claims looked like that, but it doesn't, and I'll explain what it does look like. First of all, if you look at the global figures, who's going to be appointed, ICSID have produced a sort of, it's not quite a league table, but it rather reads like one. It's a sort of bar chart that explains by nationality who's leading the pack. So the top of the bar chart are the nationality corresponding to the greatest number of appointments, at the bottom those corresponding to the fewest. And the top three are the United States, with 173 of their nationals appointed, then France, then the UK. You have to go all the way down the chart until number 28 before you get to anyone from Southeast Asia, and that's Singapore with 4 of its nationals appointed. In fact, I think they're probably the same person, and you can probably guess who they are, and there's another set of statistics to indicate that. Now, what about, apologies for the typo, what about disputes with an Asian party? Those were the global figures. Surely then, is it not the case, if there's a minority of Asian disputes and a minority of Asian arbitrators being appointed, then it must be the case, mustn't it, that it's Asian arbitrators being appointed in Asian disputes? Well, no, it's not. If you look at the figures for disputes with an Asian party, again, either as investor or as respondent state, that 2013 research makes depressing readings. So the figures for 87 to 2013, these are appointments to ICSID tribunals and ICSID annulment committees. Those are the quasi-appellate committees that consider whether an ICSID tribunal award should be annulled. The top three, again, are the US, UK and France, a bit of a reversal. So 28 for the US, 24 UK nationals appointed to tribunals, 13 from France. You don't get anyone from outside North America or Western Europe until you get to number 12 from 13 in the table, and they're Colombia and Egypt with 4 each of their nationals appointed to Asia-Pacific tribunals. If you look at the number of people of Asian origin, or Asian citizenship appointed, India has 3 of its nationals, Singapore 3, Thailand 3, and then Malaysia is unfortunately in a group struggling with only 1 of their nationals appointed to these tribunals. Now, it gets worse when you look at the individuals, because you realize that there's some double counting going on in these league tables. It's not that the US had 128 different people appointed. Some of those 128 were appointments of the very same person. So you have this difficulty of individual arbitrators, individual inhabitants of this village, repeatedly featuring in appointments. So 38 people, this is just globally, 38 people have received 4 or more appointments. It's quite useful to break down who those are. So of those, the top 11 are all from North America and Western Europe. Number 12 is from this region, but from New Zealand, not South or East Asia. You then go back to North America and Western Europe until you get to number 18, and there are 6 Australian nationals in that slot. There's nobody from Asian until you get to number 38, who's that Singaporean with 4 appointments, and it's perfectly obvious it's Michael Huang. There's no secrecy about that. Well, what are the implications? Well, from a scientific point of view, very few. The same Morgan-Maguire research in 2013, which produced this, I think, rather helpful and graphic statistical breakdown, also found that there's no correlation between nationality of arbitrator, in other words, are they an Asia-Oceanian national or not, and outcome, in other words, was the claim upheld or dismissed. But from the point of view of public, and particularly state perception of the process, it's a PR disaster. We used to joke, in fact, less of a joke in this region, that the British and Americans used to negotiate by sending gunboats up the Yangtze. We don't do that anymore. We just send you arbitrators to determine your cases, and it is a huge problem of perception. So why is this happening, and what can we do about it? Well, quite a lot's been written about this, but it seems to me quite obvious that given the relatively slow uptake of investment arbitration in this region, there is inevitably a sense that nationals of states who have been involved for longer and more frequently are bound to have a head start. There is more experience among practitioners from those states, and inevitably those individuals have had an opportunity to develop a reputation. It's much harder for practitioners or would-be practitioners in a region where there's simply less experience of this kind of dispute. But I think there are also other explanations. Investment law, with an emphasis on the resolution of investor-state disputes, is a mainstream feature of the academy in Western Europe and the Northern Hemisphere. In US universities, certainly universities throughout the EU, there are chairs, there are seats, there are lectureships which specialize in this area. The academy in public international law in Asia has been focused historically on disciplines which much more reflect the geography and the geopolitics of the region. So, for example, the law of the sea. Many superb academics in the law of the sea. And I think one of the changes that may need to be made, clearly what KLRCA is doing is aimed largely at practitioners and the bench, but I think there probably needs to be something of an effort to reorientate, to mainstream trade and investment law in the academy, in the Asia-Pacific region. I think it's also important that states think very carefully about who they want to appoint. The knee-jerk for most states, and indeed many claimants in ISDS arbitration, choosing who to appoint is to go for a professor of international law with a pedigree of publication and arbitrations to his or her name. There is a dearth of experienced commercial practitioners on these tribunals. Now, what's interesting about the Asia-Pacific region is that there certainly is not a dearth of experienced commercial arbitrators, including international commercial arbitrators. They're some of the most able and experienced arbitrators globally in this region. And I think there is a problem of both states and claimants feeling shy about appointing commercial practitioners to ISDS tribunals. And there are a number of very good reasons, which have absolutely nothing to do with this problem of gunboat arbitration and legitimacy, for addressing the balance slightly. It's all very well having professors of international law on tribunals, but increasingly what you need, particularly in sectors such as energy and extractive industries, are people who are in a position to understand the technical issues, handle complicated facts, and make findings. And in particular, people who understand how to handle quantum. Historically, quantum has been dealt with in an extremely unscientific way in investor-state arbitration. That isn't surprising because public international law generally has historically had a bit of a blind spot to questions of quantum. The jurisprudence, for example, of the jurisdictions that I'm particularly familiar with, which is the Regional Human Rights Court in Europe, the European Court of Human Rights, explicitly says, well, we have a restitutio in integrum principle, but we're simply going to take what we call an equitable approach. And that is because historically the members of the European Court of Human Rights were professors of law who didn't get quantum and broke out into a cold sweat when they saw a page of figures. I'm sorry to be flippant, but I think there is a difference in experience in handling some of those issues. So bringing a dose of commercial experience onto the tribunals would, I think, be a good thing when it comes to handling factual and technical issues, and in perhaps bringing a slightly more scientific approach to bear. And you can see this in the quite extraordinary trend in quantum. The pendulum has swung quite markedly. There was a whole series of cases, probably going back 10 or 15 years now, in which states were found in violation of the fair and equitable treatment and expropriation provisions of their bits, but an award was made on an equitable basis which plainly undercompensated. Feeling stung by criticism, tribunals have now swung the pendulum in the polar opposite direction, and there have now been some extraordinarily hefty claims which have indeed have prompted the hard exit of states like Venezuela and Ecuador. Massive claims, again, made by tribunals who have purported to be operating a restitutio in integrum principle, but when you look at the reasoning, have clearly had some difficulty in getting their head around questions of quantum. So there should be no shame in appointing experienced commercial practitioners, including those from this region, to international tribunals dealing with these claims. That brings me then to my next topic, this question of soft versus hard law. As I said, soft law, a hot topic in international arbitration, particularly in commercial arbitration, where the discussion has tended to focus on the various proliferation of procedural instruments. The IBA has been a particularly prolific publisher of instruments, guidance on conflicts of interest, taking of evidence, even behaviour of counsel, perish the thought, in international arbitration. There have been some substantive texts as well. Unidois is a very good example. And of course, there is a legitimacy objection to the use of these soft law instruments in international commercial arbitration, and that is that the parties have chosen a governing law for their contract, which is generally speaking the law of a particular state, and they've chosen to seat their arbitration in a particular state, and they've chosen a set of rules. Therefore, what business is it of an arbitral tribunal, so the argument goes, to introduce instruments to which nobody has agreed, but which have been published by bodies of one sort or another? So goes the argument, and I'm not going to take sides on that. Now, with investment arbitration, it might be argued there is room for a broader range of sources, particularly when it comes to substantive law, and that is because governing law doesn't work in quite the same restricted way. Clearly, the primary source of the law applied in an investment treaty arbitration will be the terms of the treaty itself. But those of you who are familiar with investment treaties will know that that doesn't take you very far, because the substantive provisions of those treaties are couched in such open-textured terms that they're a bit like the collected works of Lenin or the books of the Apocrypha. You can really make them say what you want if you put your mind to it, and therefore there's a huge amount of interpretive leeway for the tribunal, and therefore provisions, this is an example, the ICSID Convention Article 42.1 says that in interpreting and applying the treaty, the tribunal shall apply the law of the contracting state party, including its conflicts of laws rules, and here's the crucial phrase, such rules of international law as may be applicable. What do we mean by rules of international law? Well, as you know, there's customary international law and there's conventional international law. The content of customary international law, in other words, law that is developed, the common law of international law, by tribunals themselves, is in a constant state of flux. And it seems to me that there is a prospect for instruments which are not themselves legally binding to be taken into account, not as law themselves, but as evidence of what international law is, given that there's often a paucity of a hard statement of the law. Now, why might it matter that soft law instruments are going to be used in ISDS? Well, for this reason. On the face of it, investment treaties are all about the protection of economic interests. A claimant under an investment treaty is seeking to protect a valuable investment. But that's not the only category of interest which has to play in the balance. When an ICSID tribunal is applying a provision such as fair and equitable treatment or expropriation under a series of principles developed by tribunals such as the NAFTA tribunal in the Methanex case, it's got to strike a balance between, on the one hand, the state's legitimate interest in regulating investments and the behaviour of businesses who come to do business within its borders, and on the other hand, the financial, the business interest of the investor itself. Now, the general rule is that just because a state is interested in protecting, say, human rights or the quality of its environment isn't an excuse for breaching the provisions of an investment treaty. In Suez and others in Argentina, an ICSID tribunal said, well, they're both binding obligations, you've got to uphold all equally. It's only in the extreme situation where an investment is essentially illegal, where it's an investment which from the outset was in breach of the international law principle known as jus cogens, fundamental binding customary principles of international law. For example, everyone knows that genocide is illegal. Everyone knows that slavery is illegal. If you have an investment to promote genocide or slavery, well, you're not going to get very far in claiming that ought to be protected. But outside those fairly extreme examples, said the tribunal in the Suez case, the state can't pick and choose. And so that raises the question whether soft law instruments could nevertheless inform not the circumstances in which a state is free to breach its treaty obligations, but the content of those treaty obligations themselves, particularly in the context of FET and expropriation. Look at the formulation by the NAFTA tribunal in Methanex. The state has a legitimate right to regulate and to exercise what's called its police power in the interests of public welfare. And that raises a number of fundamental questions. Well, which interests count as the interests of public welfare, and what weight should those have in the balance as against the economic interests of an investor? Now, there are, on the face of it, a whole proliferation of non-binding, non-treaty instruments which deal with a range of public welfare interests. For example, environmental standards, human rights standards. I've given some examples. Sorry for the acronyms, it's the only way I can get these things to fit on the slide. UNGPs, the UN Guiding Principles on Business and Human Rights, adopted by the Human Rights Council in 2011. Another fairly well-known instrument are the OECD guidelines for multinational enterprises. And there are also the IFC performance standards for investment and sustainability. Those all, to one extent or another, impose obligations not just on states, but they also purport to set standards for businesses themselves in the way they go about their affairs. So the OECD guidelines for multinationals, just to give you an example, has very elaborate provisions about public consultation, about ensuring that information is given to the public before steps are taken which might have an impact on human rights or the environment or the rights of indigenous peoples. So on the face of it, a series of fairly precise obligations aimed directly at business. So it would seem logical that in ascertaining the content of international law standards, it ought to be open to tribunals under the ICSID system or otherwise to recognise those as evidence of the level of the scope of obligations such as fair and equitable treatment or measures having equivalent effect to expropriation. Logic may so dictate, but so far there's been little judicial traction for that idea. And I've given the example of border timbers in Zimbabwe. This is a relatively recent ICSID tribunal decision about a complaint which involved the interests of some indigenous peoples in Zimbabwe. And an NGO representing those peoples petitioned the tribunal to make a third-party submission. Interesting how substance and procedure are so intertwined. And the tribunal said, no, we're not hearing you because this is solely about economic interests. They didn't quite say the rights of indigenous people and human rights have nothing to do with it, but they came close to saying that. So far, the idea of substantive soft law instruments as a source of interpretive guidance to an ICSID tribunal doesn't seem to have gained much traction, but it does seem to have gained traction in the legislative universe. UNCTAD, this is where I'm afraid even I have to look up the acronym and remind myself. The IPFSD, the SD stands for Sustainable Development. It's an international report on sustainable development under the auspices of UNCTAD, which is of course the United Nations Conference on Trade and Development, recommended in 2012. Not entirely coincidentally, just a month after the tribunal decision in the Zimbabwe case, that we needed to look again at the extent to which soft law instruments ought to play a role. And its recommendation was that when new bilateral and multilateral treaties are negotiated, express reference should be made to the need for states to have regard to the standards set in guidance such as the UN guiding principles. And it won't surprise you to know that this appears now to have gained something of a foothold in the text, insofar as one can ascertain what the text is, of the TPPA. So modern treaty practice is falling into line with the practice of international organizations in setting up non-binding obligations in areas such as environmental protection, human rights, and indigenous peoples. So much for soft law. Let me come then to the much harder-edged question of costs, or close to the heart of all practitioners, and in particular the question of third-party funding for ISDS. Now, I can't see the clock from here. How are we doing for time? That's great. That's perfect. So about 7.5 minutes for this topic, and then about 7.5 minutes or a bit less for the final topic. Third-party funding is an arrangement for funding litigation under which a commercial funder in effect makes a loan to the claimant to pay the claimant's costs of a piece of litigation. And the loan is repayable in the event the claim succeeds by the lender taking a share of the proceeds. And it's on a contingent basis. So if the claimant loses, the lender doesn't get repaid. You can immediately see all the common law, civil procedure and professional alarm bells ringing very loudly. Maintenance, champity, contingent fee arrangements. One can see why in the common law world there are, to say the least, potential problems with this. Now, despite those potential problems, third-party funding has become quite a mainstream source of litigation funding in a number of jurisdictions, particularly in England and Wales. And that's actually part of a historic narrative in England and Wales, where previously there was quite a generous publicly funded legal aid scheme, which in fact operated like a scheme of third-party funding. So the taxpayer would effectively lend you, the claimant, the money to fund your case. Your lawyers would run the case, and if they won, the legal aid board had what was called a statutory charge over the proceeds. So the idea that a funding body might have some legitimate interest in the proceeds of a claim isn't anything new. But once commercial bodies get involved, one can see that different consideration applies. And there's a huge amount of international variation in the strictness, in the rigidity of rules derived from the common law principles of maintenance and champity. Contingent fees are a problem. So too are conflicts of interest between the funder and the litigant, indeed between the lawyers and the litigant, because there have been examples of lawyers themselves attempting to step into the shoes of the role of funder of litigation. And also, who controls the litigation? Is it the claimant? Is it the client? Is it the lawyer? Or is it the third-party funder? So a whole welter of regulatory problems raised by third-party funding. Despite that, there is absolutely no statutory regulation of third-party funding in England and Wales. So far, it's all been dealt with so far by self-regulation. And it sort of seems to work, but might not work everywhere. So what's the debate taking place in Asia? Well, it's by no means been kicked off, but I think it's been given new impetus by the Hong Kong Law Reform Commission's report, just a couple of months ago. I know there's been discussion, certainly in case law in Singapore, which I'll take a look at in a moment, about the legitimacy or otherwise of third-party funding arrangements. But this is a particularly well-researched, closely reasoned discussion by a well-respected official body of the issues arising from third-party funding arrangements, largely in relation to commercial arbitration, but also with a point of contact with ISDS, and I'll explain why in a moment. But that debate in Hong Kong is born out of a situation in which there's really a very rigid set of rules about maintenance and champity. Maintenance and champity are not only civil wrongs rendering a funding agreement unenforceable, they're also criminal offences in Hong Kong. And the final Court of Appeal in a fairly recent case in Hong Kong was asked to disapply the maintenance and champity rules to arbitration on the basis that commercial practitioners in arbitration have created a consensual jurisdiction. They're not using a jurisdiction in which there's a public interest. And the Court of Appeal said, no, there is much a public interest in ensuring that arbitral awards are reached after due process, with the stream of justice kept pure from corrupting arrangements, as in the case of mainstream litigation. And the Law Reform Commission raised a real concern about the competitiveness of Hong Kong as a commercial arbitration centre. If you have jurisdictions like England and Wales and France and other places where there's a very relaxed, laissez-faire approach to third-party funding, then if third-party funding takes off in arbitration, that's where the claims are going to go. What about us in poor Hong Kong? And so they've issued a consultation paper recommending amendment of the Hong Kong Arbitration Ordinance and also inviting views from the profession on what regulatory steps would be required to protect the public interest and the consumer interest. So what about ISDS claims? Well, it's interesting just to look at what's happened before we go to ISDS specifically, of what's happened in Singapore, a bit closer to home than Hong Kong. Very similar legal position in Hong Kong. A couple of decisions confirming that there's a professional conduct problem for a lawyer involved in third-party funding, particularly where the lawyer funds the case himself. And also that the champity rule, the rule against a third party taking an interest in the proceeds of a piece of litigation which he has only a commercial, no other underlying interest in, applies with as much rigour to international arbitration as it does to domestic litigation or domestic arbitration. And the Ministry of Law in Singapore in 2011 made some proposals to change it, which were conspicuously absent from the recent change in the law in the International Arbitration Amendment Act of a couple of years ago. So there's a lack of clarity, and those who heard the Singapore Chief Justice Sundaresh Menon here in Penang at the CIARB event in 2013 will have heard his real concerns about third-party funding. He likened third-party funding to a vulture fund market. Vulture funds, of course, those bodies that buy up claims against states which no one else will touch. They buy them at a discount and then attempt to enforce them. And he saw a real need for regulation if this was going to be permitted at all. The position in Malaysia, as far as I can tell, is uncertain. I've had the benefit of some discussions with some practitioners in this area, and the position appears to be, and do forgive me if I've misunderstood, but the position appears to be that there is real uncertainty and has been relatively little discussion about the application of maintenance champity and the Legal Professions Act and the rules of etiquette to third-party funding. And at the very least uncertainty as to whether third-party funding agreements would be enforceable and would be consistent with the rules of professional conduct if applied to international arbitration. Now, what are the implications of that uncertainty, to say the least, for investment arbitration held here? Well, the first question is third-party funding meaningful in investment treaty arbitrations at all? Well, in commercial cases, one can see the problem. The problem is that orders and awards can only be made enforceable against parties to the arbitration agreement. There's no equivalent of the court's power in litigation to award costs against a third party, such as a funder. Now, the way a commercial arbitral tribunal gets around the problem where there's a third party funder is by requiring the claimant to provide security for costs. Why? Because the need for third party funding is itself evidence of the lack of means of the claimant, and therefore justifies the grant of security. Now, there's been a problem translating that to investment arbitration, and that is because the ICSID Convention doesn't contain any explicit power for an international tribunal to make an award for security for costs. It has, however, been accepted for some years, starting with a 1999 case called Mafetzini in Spain, that the power in the ICSID Convention and the ICSID arbitration rules to grant provisional measures to protect a party could be exercised so as to make an award for security for costs in exceptional circumstances. And it wasn't until quite recently that a tribunal actually exercised that power by ordering the claimant in a case called RSM and St. Lucia in December 2013 to post quite a sizable sum in security where there had been a third-party funder. And the tribunal said, well, there are exceptional circumstances because not only in this case does the presence of the third-party funder indicate that this claimant is impecunious and couldn't meet an award made against it, but this claimant has had a track record of failing to meet or only partially meeting awards against it in previous abortive or unsuccessful ICSID arbitrations. There's also, by the way, some conduct problems in investment treaty arbitration, just as there are in potential conduct problems, just as there are in commercial arbitration. There's this very complex saga of S&T Oil and Romania, where a US district court upheld on appeal dismissed a complaint, really a conflict of interest complaint, where the original claimant, S&T Oil, in the ICSID proceedings, got into a dispute with its own funder and claimed that it was persuaded under duress to allow the funder to use against it a document which it had disclosed in the ICSID proceedings. So you can see how many potentially problematic areas there are that might require regulation. But on the face of it, you can use third-party funding with the protection of security for costs award in investment treaty arbitration. And that does raise a question about whether, just as the Hong Kong Law Reform Commission felt there was a competitive disadvantage for Hong Kong if the status of third-party funding in commercial arbitration was in doubt there, so it seems to me there are real question marks as to whether the current uncertainty in Malaysian law on third-party funding might not frustrate the ambitions of KLRCA to become a venue of choice for investment treaty arbitrations. And it strikes me that there may be a need for a legislative solution. I think there are very interesting questions to be raised for it. I've raised some of them on the slide. Would the domestic Malaysian rules on shambity and professional conduct bite on funding arrangements made under the law of an overseas jurisdiction in relation to investment treaty arbitration held in Kuala Lumpur? Very interesting question. Would Malaysian counsel acting under such an agreement be caught? Would foreign counsel be caught? It would be a bit rum, wouldn't it, if foreign counsel had an advantage over Malaysian counsel because we weren't caught by rules of professional conduct which prohibit you from acting under the contingent element of a third-party funding arrangement. So it seems to me that my guess is that a legislative solution is going to be required to create the necessary level playing field. By the way, there's no unfair advantage for English barristers because under our Bar Standards Board rules, we are bound not only to observe our own standards of conduct, but also the rules of professional conduct in the jurisdiction in which we operate. So English barristers operating here under the fly-in, fly-out visa waiver rules have to adhere to exactly the same standards of conduct as everyone else. It seems to me we would be caught by a principle that the contingent element of third-party funding in investment treaty arbitration is, or at least might be, contrary to the objections to contingent fees. And it may be that in the long term, international rules are required. It's very interesting, just to fast forward to the next topic, that the parallel to TPPA on the other side of the Americas, the TTIP, Transatlantic Trade and Investment Partnership, has spawned a very interesting investment court proposal in which the draft instrument from the European Commission contains explicit rules about third-party funding. So it's obvious that commentators in this area, and indeed the institutions in this area, think that third-party funding is here to stay and it needs to be addressed possibly at an international level. So that brings me to, just very quickly, confidentiality and transparency, and then a point or two on TPPA. This isn't really news now. I made the point right at the outset that the historic confidentiality of commercial arbitration doesn't lend itself terribly well to the much more public, much more politicized milieu of investment treaty arbitration. And the short point is that there's been an inexorable and unstoppable trend in investment treaty arbitration away from privacy and confidentiality and towards much more transparency. And so far as ICSID is concerned, that's been spawned by a change in the ICSID rules in 2006. But that was driven, interestingly, by tribunal decisions themselves, particularly the tribunals sitting under the NAFTA, the North American Free Trade Agreement, who started adopting a practice of publishing awards and particularly hearing third-party interventions from NGOs and others with an interest in the legal issues in the case. So under the ICSID rules, there is now theoretically a prohibition on the award being published without both parties' consent. But there's this very strange under-the-counter approach where if one party refuses publication, the other party can still publish it, and very often does so, with the encouragement of the ICSID Secretariat. The UNCITRAL transparency rules were probably the other significant breakthrough in this area. 2014, they create a presumption of transparency. They apply where the parties opt in the case of investment treaties concluded before the rules came into force. But for all subsequent investment treaties, they apply automatically unless the parties opt out. Needless to say, more modern investment treaties create very limited scope for the parties to opt out. But there has been an interesting example of parties who've opted in and then used the consent provisions to create quite a tailored confidentiality regime rather than all or nothing regime. So in the case of BSG Resources and Guinea, there was quite an innovative arrangement so that the proceedings were broadcast, but they were broadcast with a 30-minute delay. So if a particularly sensitive piece of information was let slip during the course of evidence or submissions, it could be airbrushed out before public consumption of the proceedings. And modern treaty practice is to prescribe that everything is in the open, and that's certainly the position under TPPA. So will it make a difference? Well, it's very dangerous for lawyers to comment on the politics of investment treaty arbitration, it seems to me. And my impression from reading The Star, no doubt a highly accurate and informative source of information over the last week, is actually much of the political controversy in Malaysia over TPPA is really about the fundamental substantive provisions about reciprocity. Should certain sectors, such as the media and culture, be protected against market access and issues of that sort. There has been some resistance to ISDS and certainly an ongoing discussion about it, particularly in the United States. But the reaction by the negotiators of TPPA has said, well, look, if you've got a problem about ISDS, we'll answer that by ensuring that it adheres to the highest standards of transparency. And not only will the openness that's now a feature of the UNCITRAL transparency rules apply, but there are also provisions for new guidance to be issued on arbitrator ethics, particularly dealing with the question of arbitrator impartiality. Now, are we moving towards an investment court? This is a really interesting debate that's been kicked off by the huge public backlash over the, as I say, what's going on the other side of the Americas, the Transatlantic Trade and Investment Partnership. The negotiation of bilateral investment treaties used to be carried on like most diplomatic negotiations in decent, or as now seems to be the consensus, indecent obscurity, in genteel former colonial prime ministers' residences and so on and so forth. ISDS is now a hot political topic. States cannot negotiate things like this in secret or without public debate anymore. There's been a massive public backlash to ISDS as proposed for the Transatlantic Trade and Investment Partnership, and that has prompted the EU Commission, no less, to make a very interesting proposal for a formal investment court in lieu of individual treaties constituted on a similar basis to ICSID. So on the face of it, if accepted, that proposal will signal a very significant fall-off in the use of international arbitration as a mechanism for settling disputes, and its replacement with something very different. And what the EU Commission is proposing is something that looks a little bit like the former part-time European Court of Human Rights, where one had national judges, retired judges, needless to say, professors of international law, and sometimes practitioners, turning up in Strasbourg for 1 week every month to hear cases as a part-time court. So the Commission's proposal is for a court of 15 part-time judges, 5 nominated by the EU, 5 by the US, 5 from third countries, each holding office for a once renewable 6-year term, and with a permanent appeal tribunal with 6 members, and there the split would be 2-2-2, and all sorts of safeguards, as the Commission puts it, for the integrity of the process. And I have to say, there are some attractions to an investment court, because it would seem to provide an answer to a number of perceived problems in international arbitration as an ISDS mechanism. And this is the very last point. One of those problems is what can diplomatically be called a lack of certainty or consistency on key questions. The way I sometimes put it in a frivolous moment is that sometimes ICSID tribunals can barely agree which day of the week it is. Sometimes individual members of individual ICSID tribunals can barely agree which day of the week it is, let alone how to solve particular problems. And another facet of that problem is what's been dubbed the issue of issue bias. Some arbitrators are repeatedly appointed by claimants, others are repeatedly appointed by states, and guess what? Those who are repeatedly appointed by states tend to have a track record of deciding jurisdictional merits and quantum issues largely in favour of states, and vice versa. And indeed, there's something of a cottage industry that's been spawned in making applications to disqualify arbitrators on the basis of the number of repeat appointments they've had, either from a particular party or, in some cases, from a particular firm that's been acting for a group of investors or a group of states. So there is a sense of something unseemly about individuals touting themselves for appointments in such a polar milieu. It's very different to commercial arbitration. In a sense, there are no claimants, men or women, or respondents, men and women, in international commercial arbitration, because the issues are simply contract issues. They may result in payment of money for one side or the other, but there isn't the same polarity. With investment treaty arbitration, very different. There does seem to be a claimant's bar and a respondent bar, and a claimant's bench and a respondent bench. And a full-time court is designed to attempt to address that problem. The final issue it's designed to address, very narrow and sometimes rather arbitrary grounds on which an ICSID award at first instance may be annulled by an ad hoc annulment panel. They're extremely restrictive. There has to be essentially a manifest excess of jurisdiction. Even sometimes a quite egregious and obvious error of law will not be enough. And the EU Commission proposal is very interesting. It's that a ground for annulment of a first instance tribunal award will be either an error of law or a manifest error of fact or appreciation, so a much lower bar. So the proposal is for a very much more judicialized system, which would look very different from ISDS. So I leave you with that thought. Very many thanks for putting up with an hour's worth of acronyms. And again, if there are any questions, contributions, expressions of incredulity, or requests for deciphering any of the acronyms, I'd be very pleased to deal with them. Thank you.
Thank you, Gordon. Quite enlightening for me. Any questions? Any clarification? Yes.
Thank you for a wonderful...
Your name and...
Yes, sure. My name is Shahrizal from Mara University Law School. Thank you for wonderful presentations. I would like to ask your view regarding a low level of claim being made against the Chinese government. As far as I'm concerned, so far, there are only two cases, two claims being made against the Chinese government as a respondent. The first one involving a Malaysian investor, Akram Berhad case, where Akram Berhad took the Chinese government to ICSID arbitrations. However, the case was settled pursuant to parties' agreement. And the most recent one involving a South Korean firm, Ansang Housing Company Limited, who took the Chinese government to ICSID arbitrations. Is it true that foreign investors are reluctant to take Chinese government to arbitrations due to a fear of retaliations that may be made not only against them, but also against the council who represent them? So what is your view on that? Thank you.
Should we take a clutch of perhaps 2 or 3 questions and then I can deal with them?
Gordon, I'm Philip Teo from ASME Associates. It has been a very illuminating talk. Thank you for that. I just want to know your personal view on TPPA, on the effects of TPPA on the legal sector in this region. Your personal view.
Hello, my name's Isaac. I just wanted to have a view about WTO, and this investor treaty. One of the problems is that WTO didn't function as it should have been. And because of that, I think people have gone into investor treaty, bilateral treaty agreements and all that. Should the WTO actually buck up and get the act straight, and that would, because it's a global organization, and that would ensure the fairness that a lot of people are actually craving for. Because investor treaty, the other problem with investor treaty is bilateral treaties are actually shrouded in secrecy. If you look at TPPA, it's all drafted in secret, and once it's signed, then they actually bring it to the public, it's a bit too late. So this could be addressed with WTO involvement, but the last Secretary General Pascal Lamy, he did say there are a lot of trouble involved, but I'm surprised that the bilateral agreements are going so fast ahead. So if they can do it, why can't WTO? Thank you.
Shall I deal with those? How do we... Great, thanks very much. I'm going to sort of take the diplomatic rain check on the question of how China might behave. The question of states misbehaving towards foreign investors and their representatives is really nothing new. There have been all sorts of rumours flying out of some of the more controversial claims brought against Latin America. But what I would say is this: bear in mind that most investors who are seeking to invest in a growing economy will want to have an ongoing business and, to some extent, political relationship. The reason why things degenerated to the extent they did in Venezuela, Ecuador, and so on was that the political change in the wind in those countries led to a situation where the governments decided actually they just didn't want to have a relationship with foreign investors. Assets were taken over or de facto expropriated. And it was perfectly obvious that there was nothing to be gained by those investors in seeking to persuade the governments to continue a relationship with them. And so the only answer was ISDS. Those countries acted as they did, not least because of dire economic problems. So Argentina had a massive problem with its foreign debt. It devalued its currency. The devaluation of its currency itself spawned a number of ISDS claims by investors. So the gloves were off, the rules ceased to apply. I think China is rather different. I think yes, China is finding its way in terms of the way the rule of law operates. But I think more importantly, most investors will see China as a growing economy. They will want to have a future relationship with it. They will want to invest in future. And as you would with any investor-host relationship, you would want to take care not to deter your host from wanting to welcome you in future. So that's my diplomatic answer to that. So you've always got to remember the economic backdrop to what's going on in ISDS rather than focusing on the minutiae of how individual relationships operate. TPPA in the legal sector, the real difficulty with TPA, and it's an irony, given that it so proudly announces its commitment to transparency, because the lack of transparency with which it's been negotiated really does leave something to be desired. And the problem is, I know the New Zealand government have posted what purports to be a version of the text of some of it online, but it's very difficult to ascertain what it contains. And I'm afraid I'm just not up to speed enough with the specific provisions about the legal sector. Of course, everyone knows that when trade and investment agreements are negotiated, the legal sector, like culture and the media and so on, is one of those sectors which raises special issues, and inevitably there's a balance to be struck between protecting high professional standards and the independence of the profession on the one hand, and ensuring that there's growth in the sector through international trade and exchange on the other. And I'm afraid I'm not up to speed enough with the detail to understand how that particular balance is resolved, so I'd rather not indulge in guesswork, if that's okay. What you have to remember about the WTO is that actually the WTO systems and the system of bilateral investment treaties have rather fueled each other over the years. So some of the modern treaty practice in BITs and multilateral investment agreements, for example, those that provide specific protections for the state's freedom of action in health, health, the environment, and labour standards, are actually borrowed from the WTO regime. So the regimes do continue to feed off each other. But the big difference is that WTO is effectively an interstate mechanism. So it's one state complaining that exports have been dumped on its markets at below cost price and so on, rather than individual investors. So in theory, the two systems ought to complement each other, with the WTO disputes panel system as an interstate mechanism, and BITs and multilateral investment agreements with ISDS chapters as a provision for individual investors. So they ought to work in tandem, and I say in practice they do inform each other. So there are instances of developments in the practice of the WTO informing what goes on in the world of BITs. The difficulty is that it's easy to negotiate a BIT because there are only two parties. it's almost easier it's certainly easier for the TPPA to be negotiated among 10 parties who've signed now than it is the WTO, which is an enormous negotiating body. And really the WTO have failed to make, they're still in the Doha round, which started however many years ago the Doha round started. And technically speaking, they haven't got agreement. And so what you have in the WTO system are a series of workarounds to address that problem. So that's why the WTO system looks as though it's failed to make progress. It has made progress under the surface, but the reality is that there's a lack of political agreement. And what's essentially a global multilateral trade organization, inevitably that's not very propitious for making progress. Who knows? An agreement might become easier once you have a series of converging multilateral agreements. So it's possible that the Canada-EU trade agreement plus TTIP, if it's ever approved, plus TPP will be gradually, a majority of WTO nations are already adhering to standards which are agreed, as to which there's consensus, and it might then be possible just to bridge the gap and find that there's agreement globally as well. Who knows?
Any other questions? Anyone? I have a question, Gordon. I mean, when you look at state investment disputes, how detailed are the procedures or the processes in the agreement itself when it comes to law and dispute settlement? Normally you have a contract, you state what law to apply, what you do, which courts, jurisdiction and all that. And a trade agreement, it probably be one of the more minor issues that they want to talk about. So how do you actually make sure that, how detailed it has to be? It seems like the TPPA is the only one now which seems to have a little bit more detail on processes and procedures. So your normal bits and all that, how much detail is there in those agreements?
There's been quite an evolution in practice. Some of the earlier bits, Malaysia's first bit was in the, I think, early to mid-60s. And some of the early model bits, much the same, very simple form was adopted right down until the early to mid-70s. Actually said very little about arbitration. They simply contained a provision requiring the state to submit irrevocably to binding arbitration. And it was for that reason that the ICSID Convention, the Washington Convention, was introduced in 1965. It really has been with us for a very long time. It was precisely to provide a mechanism for parties who have provided only the bare bones of a submission to arbitration. So it's really under the aegis of the ICSID Convention and the detailed arbitral and mediation rules that provides for that the procedural gaps have been filled. As I say, the practice has changed, and it's now much more the practice for treaties themselves, particularly complex multilateral treaties, to contain their own provision. And what you typically have now in a treaty, which will feed into an existing structure such as ICSID, is a structured multi-tiered settlement provision, just as you do in commercial agreements, where the parties get together, manager level, and then if that doesn't work, they appoint directors, and if that doesn't work, they mediate. You have to be very careful, because it's very easy to create a pathological arbitration clause where one party can spin out the mediation or the negotiations indefinitely, and you can never trigger the right to arbitration. The same risk applies theoretically anyway in bits. I do quite a lot of work in the energy sector, and therefore under the Energy Charter Treaty, which is largely an intra-EU treaty, but of course it does include the former Soviet republics in Central Asia, Kazakhstan, and so on, who are major players in power and gas and oil. And that has a quite interesting provision in Article 26. There's a provision for a party to propose an amicable settlement, and there's then a 3-month cooling off period. And needless to say, that's spawned satellite arbitration disputes about whether that's binding, whether a party can nevertheless commence arbitration, does commencement of arbitration during the cooling off period deprive the tribunal of jurisdiction, and so on. So anyone who's familiar with commercial arbitration and some of the problems that these multi-tiered and settlement clauses can cause will be on familiar turf when they look at some of the disputes that have arisen under these mechanisms. Energy Charter Treaty is interesting because it gives the parties a choice of procedure. The parties can launch an ICSID claim, or they can go ad hoc under the UNCITRAL rules, or, this is quite interesting, they can use the Stockholm Chamber of Commerce. So the Stockholm Chamber of Commerce is a place where the Russians like arbitrating their energy disputes, and it's also where increasingly disputes against EU member states are being arbitrated. It's another indication of the changing times. EU member states thought the Energy Charter Treaty was a brilliant idea because they thought it was going to be their multinationals suing former Soviet republics what's now happening is that is it's the other way, the boot's on the other foot, and so there's been a distinct cooling, and so it's quite an interesting area to be involved in. I hope that answers the question. Thanks. Clearly be in my interest to pretend that no commercial arbitration practitioner could possibly get their head around an investment arbitration, but that's not the position. An arbitration is an arbitration. Yes, it helps to understand the public international rules, but ultimately it is an arbitration. It's before a panel of arbitrators. There are pleadings. There is evidence. It's not that difficult. I know it's a bit like magicians who give away the secrets of their tricks, but there's no reason why commercial arbitration practitioners in this region cannot very quickly become highly competent experts and sought-after appointees in investment treaty arbitration. I think there probably is a case for a slightly more structured approach to changing. These kind of events organised by KLRCA certainly help, but I suspect they're not a substitute for the organisation of serious courses, perhaps over a few days, much like the courses that the CIARB run in Penang and elsewhere, which go from start to finish, and you end up being theoretically at least given award writing skills and an awareness of ethical issues affecting arbitrators and so forth. There's no reason why there couldn't be a series of intensive, partly academic, partly professional courses adapted for those interested in trade and investment arbitration. But the key message is, it's interesting, but it's not that difficult.
Right, legal practitioner from Johor, and I was also the chairman of the Malaysian International Chamber of Commerce for Johor State. I was rather interested to find out a little bit more about the influence of soft law, as you mentioned, and what you mentioned as well was, what was the weight, what was the interest? Because you've also referred to the United Nations, some of the business and human rights regulations. What happens if the states are investing, or the countries that are investing in, say, for example, Malaysia, are not party to any of these treaties in the UN? For example, Saudi Arabia, there are investments from Saudi Arabia in Malaysia. There are investments that someone mentioned earlier from Taiwan. Taiwan's not really recognized, or even from Israel. What happens then?
Well, clearly there can be no ISDS unless it's between parties who have agreements. Now, there is a way around this, and I know Lucy Reed touched on this in her presentation 2 or 3 months ago. When you are structuring an investment, you can be clever about this. Malaysia, for example, does not have a bit with a number of states where parties might wish to invest. For example, I think the example she gave was Mexico. However, Switzerland does. So what a Malaysia investor might do is structure its investment so it makes its investment via subsidiary in Switzerland. Now, this starts creating problems when you have, say, a Mexican investor trying to make an investment in Mexico through a subsidiary in Switzerland. Then you get this question of whether there's the necessary reciprocity. And that's one of those classic issues where two ICSID tribunals just can't agree what the answer is, and there's a lack of consistency in the jurisprudence. But really, I think the question you pose is about how you structure your investment in the first place. Because clearly, if there's no bit between the two jurisdictions, then there can be no claim. Sorry, you asked me about soft law as well.
Yes.
Well, at the moment, soft law instruments haven't really taken root among ICSID tribunals' sense of the range of true sources of international law, because they don't have the status of treaty obligations. No doubt there is some coincidence between what you might find in a soft law instrument, such as the UN Guiding Principles on Human Rights, and what a tribunal would be prepared to say is a peremptory norm of international law, a jus cogens principle. And I was slightly exaggerating when I said it's all about genocide and slavery. I mean, there are other principles to do with treatment of minorities and so forth, which are equally treated as part of jus cogens. So where a soft law instrument is treated as codifying a peremptory norm of international law, then it will be taken into account. The problem arises where parties have attempted to use a soft law instrument to take international law further than any binding obligation is acknowledged to go, and so far that hasn't happened. And so it's in the practice of negotiating new treaties. To that practice we have to look to see any move to incorporate these soft law instruments into international law standards that would be applied by an ICSID tribunal.
I think that's really exciting because, you've got a lot of environmental issues now.
Yes, my name is Nitin Nadkarni. I'm a practitioner in Kuala Lumpur. This perhaps isn't a legal question, but I'm curious to see what your reaction might be. If you accept that the establishment of the rule of law is driven primarily by economic interests, and Singapore is a very good example of that as a country which, for economic purposes, established a very sound commercial legal system. By carving out a parallel and different system of dispute resolution for what one might call more powerful and more informed economic interests, would an ISDS provision not actually undermine the establishment of the rule of law for the rest of the society?
That is precisely how the debate over TTIP is being framed, and you can see why historically it's been framed in that way. The position in the 1960s when, say, British or American or Swiss investors wanted to, say, invest in a desalination plant or a power plant in sub-Saharan Africa, in a country where the rule of law was fragile, you can see there might be real fears that the domestic judicial system couldn't be relied on to defend those interests, or at least defend them to the same extent as it might indigenous investment interests. And you could see why there was a political case for giving rights to foreign investors separate from, and it might be said over and above, the rights the domestic investors would have. I think it's clearly right that that case gets weaker the more we succeed as an international legal community in entrenching the rule of law in jurisdictions around the world. And The Economist put it, which is not generally thought of as being a very radical publication, put it very neatly, and I can't remember precisely how it was put, but they ran an editorial about TTIP saying, suppose you proposed a system of dispute resolution in which wealthy multinational companies had their disputes determined by secretive tribunals of well-paid commercial lawyers, held meeting in private, who could make a multi-billion-pound damages award against states. Would you get very far making that case? And of course, put that way you wouldn't. And I think what's happened is that the public have rumbled what's been going on. There's a very interesting, I was reading up an academic analysis on the Australian Gillard government's acceptance of the Productivity Commission's proposals. And the product, I can't remember if it was the Productivity Commission or the academic commentator, but they use an expression from social psychology, which is called path dependence, which is kind of habit meets a herd instinct. So there was a case historically, perhaps, for setting up a separate system of dispute resolution to ensure that the rule of law was observed. Everyone thought, oh yes, well they've done it, so we better do it because that's what states do when they're trying to attract foreign direct investment. Until quite recently, the international diplomatic community has been sleepwalking into signing bits for those provisions. I think what's happened is that the public have said, no, we want to see a real justification for these provisions. And I think the EU Commission's proposal, which is to have a court rather than tribunals, in other words, let's sell the public something that's much more familiar to them. We already have in Europe two transnational courts. We have the European Court of Human Rights and the Court of Justice of the EU. Everyone apart from the British government, that is, seems to think that's a good idea. So let's present something that looks like that, because that's a bit softer and cuddlier. So you can see how that argument has in fact informed some of the proposals for reform that are now being made.
Thank you. That's illuminating, but that's not exactly my question. The point I think I was asking was that, taking your example of the desalination plant in a sub-Saharan country which might not have an established rule of law, and you have a large, powerful foreign government which is prepared to invest through whatever aid, by creating a separate legal system that protects its own citizens, if you like, that undermines the need for these governments to improve the rule of law within that jurisdiction for persons who might not have the benefit of being citizens or residents of a large, powerful government. So in that sense, you're removing a portion of the impetus which otherwise would come. Otherwise, it would be in everybody's interest to improve the rule of law. So would you say that these sort of, in less developed systems, in fact undermine the rule of law, not because of justice not because you're treating foreigners differently, but because you are actually removing the impetus for treating locals to that same standard?
I think a persuasive case can be made along exactly those lines. You can almost say that it lets those states off the hook. They can say, well, we're treating our foreign investors okay, so you foreign states keep your nose out of our affairs. You've got no complaint because your investors can go before an ICSID tribunal. So I entirely take the point.
Thank you, Gordon. Very helpful, and a big hand for Gordon.
I'd like to call upon Ionis, KLRCA's Head of Investment Treaty Arbitration and International Law, to present tokens of appreciation to our presenters this evening. Can you please put our hands together for Gordon Nardell, QC. Can you please put your hands together for our moderator, Mr. Raghunath Kesavan. Thank you, Evanis. And before we conclude, can I just divert your attention quickly to the two brochures in your file? As Mr. Gordon has touched upon earlier, there's this upcoming course in Diploma in International Commercial Arbitration, which runs from the 9th to the 17th. It's a very comprehensive course. Seats are still available, extremely limited, so if you want to sign up, please do so quickly. And we also have the KLRCA International Investment Arbitration coming up in March. Please mark down your dates, and we hope to see you there. And on that note, do stay back for some refreshments, and thank you very much. Have a great day. Thank you.